Good evening, welcome, and to those who are here assembled and to those watching on TV 23, I'd like to call to order this meeting of the Cobb County Board of Ethics. The first item is we're required to recognize a quorum. It requires 4. It appears that we have that. The first thing I'd like to move to then would be the introduction of the board members. So I'd like to start down here in the end, and if you would introduce yourself and tell us what entity has elected or appointed you to this board.
Thank you. I'm Joe Atkins. I am elected by the county employees and appointed by the county employees.
Angela Patterson, Civil Service.
Deborah King, and I was elected by the homeowners associations of Districts 4 and 1.
I'm Doug Shaddix. I was appointed by the Cobb County Board of Elections.
I'm Richard Ziober, and I represent the homeowners associations in districts 2 and 3.
I'm Maurice Gibson, and I was appointed by the Board of Commissioners.
I'm Carlos Rodriguez. I was appointed by the Cobb County Bar Association.
Thank you. The next item on the agenda is to approve the minutes from our last meeting of May 28th, 2018. So motion?
So moved.
Second.
Motion to approve the minutes and seconded. All in favor? Aye. Any opposed? Without objection. The next item is to move toward old business. We have none. Is there any old business that any of the members of the board would like to raise? Okay. That takes us to the new business, which is, I guess, the reason that we're here tonight for the investigatory review. A complaint filed against commissioners by Mr. Larry Savage. So I'd like to introduce our counsel, Mr. Lynn Rainey, first, and have him give us an explanation of the proceedings and legal considerations.
Thank you, Mr. Chair. The purpose of this public meeting of the Cobb County Board of Ethics, which is being broadcast on TV 23, is to conduct an investigatory review to consider a complaint filed by Larry Savage against members of the Cobb County Board of Commissioners. The Ethics Board is required to proceed strictly in accordance with the Cobb County Code of Ethics. We will follow the rules set out in the code and will take such action as is authorized and required by that code. The board will be transparent, fair, and impartial to each of the parties. The next step under the code, when a complaint and reply are filed, is to conduct an investigatory review. We must meet in public to discuss the matter. The board members have not previously met and discussed this matter. The board members have received copies of everything the parties have filed and had the opportunity to individually review in the privacy of their own homes and offices. Tonight will be the first occasion that the members will have to discuss the matter, and nothing has been decided. The sole purpose of an investigatory review is to determine whether specific substantiated evidence from a credible source exists to support a reasonable belief that there has been a violation of the Cobb County Code of Ethics. Mr. Savage and Ms. Dance, this is your opportunity to tell the Board of Ethics in person why they should either proceed or not proceed with this complaint. You have been provided with these instructions previously, but let me remind you of them to make sure anyone else present or watching knows how we must conduct this matter. The Ethics Board will not be hearing your testimony or testimony from your witnesses during this investigatory review, or considering affidavits, documents, or materials not already filed with the clerk of the county commission and previously provided to the Ethics Board. The board will only be considering the filed written complaint of Mr. Savage, the written reply of the commissioners through the county attorney, and filed affidavits, documents, and materials. You are invited to state to the board in this meeting how the materials already filed support or do not support a reasonable belief that there's been a violation of the Code of Ethics. Please understand that Mr. Shaddix, who's the chairman of the board, has the responsibility to ensure this meeting proceeds in an orderly, civil, and respectful manner within the bounds of the Code of Ethics, and so he must retain the discretion to limit or terminate presentations should they stray from the matters subject to our jurisdiction. The board will first hear from Mr. Savage. When he is through speaking, it will hear from Ms. Dance. The board will then discuss the matter here in public and vote. There may be questions asked by the board of Mr. Savage and Ms. Dance if they feel it'll help them more thoroughly understand your position and help them reach a decision. The board will then discuss the matter here in public. Will not be recessing to any rooms. It'll all be done here in front of everyone in public, and they will vote in public. If a majority of the board determines that specific substantiated evidence from a credible source exists to support a reasonable belief that there's been a violation of the Code of Ethics, a public formal hearing will be set at a later date at which both parties will be allowed to testify under oath, present the sworn testimony of witnesses, and evidence. If the board, after such a formal hearing, determines clear and convincing evidence shows a violation of the Code of Ethics, it may issue a censure or a reprimand of a commissioner. However, if a majority of the board determines tonight that no specific substantiated evidence from a credible source exists to support a reasonable belief that there's been a violation of the Code of Ethics, it will dismiss the complaint. Mr. Chairman, I yield the floor to you to preside over this investigatory review.
Thank you, Mr. Rainey. We appreciate you and all you do for us. Thank you for your counsel. Mr. Savage, you've filed a complaint, and would you please address the substance of your complaint and provide specifics as to how and why we should move forward to a future hearing of testimony and additional evidence? And so you're formally recognized. You have the floor. If you would give us a brief introduction of yourself and
All right, good evening. I am Larry Savage. I filed this complaint as a private citizen. I'm not an attorney. I'm not represented by counsel. Full disclosure, I have lived here in Cobb County since 1976, mostly in exclusively in East Cobb. I have been involved to some extent or another in community affairs for the last several years and have been a candidate for chairman of the county commission. That has absolutely nothing to do with my filing of the complaint. I will tell you, this is not the first ethics complaint that I filed. I filed one in 2014 that was dismissed. And I will tell you in all honesty, I don't think it should have been dismissed, but it was a time of great confusion and disorganization for just about everything that was happening in Cobb County at that time. Again, it is not an act of defiance. It is not an act of acrimony. It is an act of, the filing of this complaint is an act that is primarily driven by the fact that I know a lot more about the county's affairs than most people, and I see things that I think a lot of other people don't see. And because of this, in 2014 and 15, I was involved in a legal action on the validation, against the validation of the bonds to finance the stadium. And I'll get to that more fully momentarily. But I just want to make sure that you have an understanding that I do have some prior connections to the county business or county affairs, but I want to make absolutely certain that you understand that is not the source of my complaint, my ethics filing in this instance. The complaint that I have filed basically contains three parts, and I hope that you will consider the three parts separately and not collectively. The first item is that county officials expended funds in excess of published statements of capped maximum of $300 million. This is probably the one that is going to be the most contentious because as you read through the documents over the last few years, which in the evidence in this case will consist of some of the agendas and minutes from commission meetings, and eventually conclude with the document that I provided with my filing of the financing of the stadium construction, you will see different storylines emerge. One storyline is that the county's contribution is capped at $300 million. That is all that the county is going to pay, and that includes $14 million in transportation improvements that were listed in the various documents, and includes $10 million contributed by the Cumberland Community Improvement District, which they paid. So basically, the county's contribution minus the 14 and the 10, the county's contribution will be $276 million. Then on the other channel that you'll see in the documents, the county actually spent approximately $380 million. And that's based upon the bond financing that was obtained at the time. One of the arguments that has come forward is that I should not have, or that my complaint is not timely because this goes back so far, and I will touch on that again shortly. The second item in the complaint is that in 2017, the Cobb Commissioners authorized another payment to the Braves of $11,300,000 roughly. And that was not adequately explained at the time. There was no documentation provided, and it has remained a mystery ever since exactly why this payment was made. That is actually what triggered my interest in this to the point that I started to do research on the subject. I had a vague memory from 2013 and 14 that there was a number that included all of the county's contributions. And sure enough, when I looked it up, I discovered they call this an infographic that was circulated broadly at the time. There was the summary of the cost of the project to everybody, and it says on here, the Atlanta Braves, $372 million overall investment, a local contribution, $300 million. And below that, it says Cobb Transportation contribution, $14 million, and Cumberland CID contribution, $10 million is included. It's very, very difficult to decipher it any other way. It's a very straightforward document. Subsequent to this, about 2 weeks later, the Board of Commissioners voted to go forward with the stadium project based on a memorandum of understanding. The memorandum of understanding includes this Exhibit A, plan of financing. And the plan of financing says that A&LBC, which is the Atlanta National League Baseball Club, their contribution will be no less than $230 million. The county contribution will equal $300 million and is comprised of the contributions from the county and the CID itemized below. $14 million for transportation improvements, $10 million from the Cumberland CID. So again, we've reinforced the same message, and this was a common message. This was a continuing theme throughout the period of time when the stadium project was being debated and discussed so much. When I saw this last year, that another $11,300,000 was being contributed to the Braves, I couldn't imagine how that could be coming forward here 2 or 3 years after the fact. Based upon media reports at the time, the Braves were asserting that they had not received their $14 million in transportation improvements around the stadium that had been included in the original documents. But media reports back in 2013, 14, 15 said that staff people in Cobb County, the DOT director, actually Mr. Massimo at the time, and later Mr. Wilgus, and the county manager had said that we had met our obligations and we didn't owe them anything. Now, all those people are gone now. And the Board of Commissioners concluded that they would pay them the $14 million, although they did find a way to bargain it down to $11,300,000. When I go back now and look at all of these documents, inevitably I find that the $14 million, which was the basis for this last payment, was included in whatever the county had paid up to the maximum of $300 million. And if we paid $380 million, surely to goodness we had met our obligations. So we have a great big mystery remaining about the $11,300,000 that we have already paid to the Braves. And by any representation I can find, anything I can find in my research, we didn't owe them the money to begin with, and had already overpaid them significantly on the stadium project from the beginning. The third piece of the case is that the $11,300,000, not all of it, but the largest portion of it, over $11 million of that money, was taken from the Cobb Water Department reserves. Now, the Cobb Water System sets up reserve accounts so that they put money aside for future needs. They know that their system is going to have to be expanded, going to have to be modernized periodically, and they put money aside in these reserve accounts to do that. The account that was charged was the R&E account, the renewal and extension for the water system. So $11 million and some change was taken out of that to make this payment to the Braves. And as a result, the water system is going to have to replace that money, and I really think that probably played into the recent announcement that we're going to have an increase in water rates. It's not the increase in water rates. My complaint is that it was simply improper for the Board of Commissioners to take this money away from the Water Department that had been responsibly put away for a Water Department purpose. These items turn into violations of the Ethics Code as follows. The number one and number two items, the 11.3 million payment and the $300 million cap being exceeded, attached to a section of the Ethics Code 2-45, which requires that commissioners operate in compliance with applicable law. And in this case, the applicable law is the Georgia Constitution. The Georgia Constitution contains a gratuities clause, which states, and I paraphrase here, states that county government or any government resources cannot be handed over to the benefit of a private party other than another part of government or a bona fide public service. What's the word I'm trying to think of? To a charity, a bona fide charity, beg your pardon. Not a word I use very often. So the gratuity clause has been violated. Also, Code Section 2-46, this is in the Cobb County Code, no officer shall give preferential treatment to any person, which they did in the case of the Atlanta Braves. They gave the Atlanta Braves $11 million, which they don't do for anybody else. And also, no officer, this is part of the code, is also, no officer shall impede government efficiency and economy. And taking the $11 million that had properly been reserved by the Water Department certainly does not serve well the operation of the Water Department. Code Section 2-50, no expenditures of county funds shall be made except in accordance with the county budget or amendments thereto adopted by the commission. And that refers again to the $11.3 million to the Braves, because that money was approved for payment to the Braves without any money in the budget to back it up. And that's why they went to the water system to get the money to make that payment. Had they lived with and followed Code Section 2-50, they couldn't have made the payment to begin with. This also would have prevented other episodes of having made expenditures exceeded the budget, because principally it says you can't spend money that's not in the budget. I want to talk about the timing of this. Ms. Dance has taken issue with the timing, because there is a 6-month limit in the ethics code that an ethics complaint must be made within 6 months of an event that's an ethics violation. The only singular event here that really, the one singular event that really begins the timing, in my opinion, is we go through in the beginning here, November 2013, when the project was announced. About 10 days later, the MOU was voted on. May 27 of 14 is when the commissioners voted to adopt all the documents involved in the stadium project. May 26 of 15, which is a year later, the commissioners voted to approve a resolution adopting the final guaranteed maximum price for the stadium. And in May of the same day is a press release from the communications office. And I might point out that press release in 2015 said, the county's cap contribution remains $300 million. The costs of any such BCC, which is an abbreviation for one of the Braves units, the cost of any BCC additions or modifications shall be the sole funding responsibility of the Braves parties, regardless any project costs that exceed the county's cap contribution of $300 million. So as I said at the outset, the references to the $300 million cap continue to emerge over the years. And fundamentally, I think it's important to note that the items, the mentions of the $300 million cap are most often found in documents that are publicity documents or outreach documents that are intended to reach the public. All the references to the $368 million contribution are buried deep into documents in places hardly anybody ever goes. So yes, I will acknowledge to Ms. Nance that the references to $368 billion investment is there, but the far more dominant reference is to the $300 million cap, and that is the image that was put in the minds of all the people of Cobb County at that time. But we get around here to June the 13th of last year, and the commissioners voted to approve the $11.3 million to the Braves. But then May 21st of this year, 2018, is the occasion when I use the Open Records Act and obtain the history of the expenditures on the stadium project. And until that date, May 21st, 2018, I didn't have documentation that would make a case out of any of these other things. So yes, I had part of the story 3 or 4 years ago. I didn't have the whole story until May 21st, 2018. That's when I knew the money was actually used to build the stadium and in its entirety, and there were no refunds, there were no other later transactions that would erase it. It absolutely was $368 million. On May 30th, I sent a message by email to the commissioners with all the same questions that are in this complaint. The next day, I received a message from Commissioner Ott that the chairman had asked him to look into it and get back to me with the answers. Days went by, I heard nothing again. And then finally, on June 18th, I made the initial filing of the ethics complaint. It was found to be somewhat deficient, and I reissued it after that on July 25th and had corrected the deficiencies that were in it originally. And that is a document that's under consideration tonight. A lot has been said about the, in the response from Ms. Dance about the court case that we had in 2015 on the bond validation. I was involved in that. We lost at the county level with the Superior Court of Cobb County, and we then had to make a decision, and I decided based upon what I had learned from my research that I would appeal it, and we did appeal it to the Georgia Supreme Court. They ultimately rendered a decision that was favorable to the county and the Braves and did validate the bonds. I will tell you, though, if you think that this was a frivolous enterprise, it was not. It was based upon constitutional questions. The debt clause of the Constitution says with no ambiguity whatever that the people will vote in a referendum before debt can be incurred. That's paraphrased, but you won't find anything different about it when you read the actual text. The Constitution also says that revenue bonds cannot be serviced with money taken from taxpayers, and, quote, the power of taxation, unquote, cannot be used to service revenue bonds. And if you followed the case at all, you know that those things are being done. So that was the basis for the case in the court. The resolution and the decision by the court, in the simplest possible terms, is based upon a precedent from 1952. And if you go and read all those sections of the Constitution in 1952, which was the 1945 Constitution, or if you read the current Constitution, you will not find how the court got there in 1952. But a precedent is a precedent is a precedent, and that is the precedent in this case, and that's how they ruled. But I will go to my grave believing that I had the right case and that we should have had a referendum. And that's why we went to court in 2015. The fact that we lost in court in 2015, and I say we, there were a couple of other people involved, the fact that the position didn't carry the day is because of the precedent case and some incredible historical rulings on some of these issues. But the court did not rule on anything other than the questions of the bond validation. The court did not rule on the cost of the stadium or how the money was distributed or anything having to do with the issues that are involved in these ethics cases. It was and remains very tightly focused on the bond validation and those issues, and it should not be seen as indicative of whether there are any ethics violations involved in the case here today. One other thing I wanted to comment on was the evidence. There is evidence, and as I said previously, the evidence consists in a great many instances of agendas and minutes from commission meetings. But very importantly, it consists of this schedule of all the payments that were made to dispense with the 500 and some million dollars that were involved in building the station. And hopefully you got a copy of this along with your copy of the complaint. But basically, at the very least, we certainly got outsmarted on the stadium deal. I don't think anybody would argue about that. But I think that we have a situation here on the $300 million cap. The question is not a question of contracts. If you want to make it a question of contracts, I'll surrender right now, because you can go and find the $368 million in the deep pockets of the official documents. The question is between the Board of Commissioners and the public. And between the Board of Commissioners and the public, we were capped at $300 million. Now, Ms. Dance has pointed out that if I had plowed through all of these documents very carefully, I would have found the $368 million was authorized to be spent. And I'll concede that information is in there. But I'd tell you this, I don't think anybody plowed through the documents that thoroughly, and I don't even think our commissioners would go that thoroughly. But if they did their job, they would know what they were voting on, and they would know it was $368 million. And if they were alive in Cobb County at that time, they would have known all these documents were around with a $300 million cap, and they would have recognized that discrepancy. So on the one hand, you can say, I didn't get my job done because I didn't find that $368 million in those official documents. But the people that are in elected office didn't find that discrepancy between the $300 million in popular documents and the $368 million in the official documents. They have missed more than I did in this enterprise. In any event, the question about the $11.3 million payment remains, and the question about the improper use of the funds from the water department remains. The water department is a part of the county government, and it could be argued that the water department's funds are at the disposal of the county commission. But we do have a separate management structure in the water department, and they do run their business responsibly, and they do set aside reserve funds for the future for known charges that they will incur in the future. And it's simply wrong to take that money away from them, especially when we take it away from them for a reason that was not planned, not expected, not forecasted, not budgeted. So that will be the end of this for me, and I'll welcome any questions.
Thank you, Mr. Savage. We appreciate your time, your effort, your research, your passion, your concern. Are there any questions from the board to Mr. Savage before we recognize Ms. Dance? There will be questions afterwards or both of them. Does anybody have anything now that you need to ask for clarity? All right, Ms. Dance, you're recognized. You have the floor. If you'd give us a brief introduction telling us your official capacity, we'd be grateful.
Thank you. Good evening. I'm Deborah Dance. I'm a Cobb County attorney. I've been a Cobb County attorney for about the last 5.5 years. The Braves transactions were something that came along immediately after I took office. And so I'm very familiar with them. And actually, I stood beside Mr. Savage before the Supreme Court of the state of Georgia. So we both have some familiarity with all of this. I also normally sit over here at these meetings, and so I've been present at Board of Commissioners meetings over time and observe the actions of the Board of Commissioners. So I come and represent on personal knowledge the matters that I have presented in my response. Particularly, I want to make one point. Mr. Savage seems to speak to a press release as being a communication by the board, and this is not something that's addressed in my document, but a press release is not a communication by the board. The Board of Commissioners acts by official action, sitting in the seats that you sit in now, and their actions are committed to a public record. My arguments are based upon the public record, and that public record occurs in front of the many citizens who come and appear at Board of Commissioners meetings and who watch it on television, and who also may scrutinize or review the minutes of the Board of Commissioners. So the Board of Commissioners transacts its business in public, and it's based upon a public record that my petition or my response is brought. I believe you all have a copy of that, and Mr. Savage is correct. What my contention is, and what the county's contention is, and each member of the Board of Commissioners that is alleged to have violated the provisions of the Ethics Code, is that no such thing has occurred, particularly because at this juncture, what you need to look at is whether or not his petition is technically deficient. And it is our position that his petition is technically deficient and is not brought in a timely manner. All of the actions that he alleges were concluded more than 6 months and were a matter of public record more than 6 months prior to the filing of his petition. Mr. Savage has been extremely diligent over the years, bringing these matters to the attention of the courts. He filed an action or he was one of the interveners filing an action in Superior Court. He appeared personally before the Supreme Court of Georgia. He personally challenged the legal sufficiency of the bonds, which is his point number one in his contentions. All of these things were resolved. I have attached the official opinion of the Supreme Court decision. All these things were officially resolved in 2015. So why we're here 3 years later to talk about matters that as a matter of law have been established by the Supreme Court of the state of Georgia is a mystery to me. In addition, his documents indicate, and I have attached more official documents to that to my affidavit, but his documents indicate that as to his second contention, that actions taken in 2017 on the record in this room with the board meeting as an official body to approve $11.3 million payment to the Braves his contention is that is somehow inappropriate. Certainly the record that I presented to you, the official minutes of the board indicate that all of those transactions occurred 1 year prior to the time that he brought either his original or amended complaints. So the fact that he says that he filed an open records request earlier this year is not to the point of the official actions of the Board of Commissioners, because the official actions of the Board of Commissioners have been before the public since the date that those things occurred. And I suggest to you that there is reasons that the code recognizes that matters of this nature should be brought in a timely manner, and that's specifically because you can't go back and flashback every transaction that's taken 5 years and say, well, at this point, I don't believe you did this right or that right or whatnot. And the challenge and your duty is to determine whether or not there was a violation of the Code of Ethics. I submit to you there wasn't. The only position that is even brought forward in his complaint is that it is a violation of law. I would submit to you that that was settled in 2015 by the Supreme Court. I submit to you that his most recent contention that in 2017 certain actions were inappropriate by the Board of Commissioners, they were fully on the record, fully established, fully completed in 2017. The record is before you, and I would ask you to find that his application is technically deficient and not to consider his complaint and to dismiss it.
Next question.
Thank you. We'll now open the floor for discussion, or I should say for questions of both individuals. Yes, sir.
I have a question of Mr. Savage,
Atkins.
and I just want to make sure that I follow something that you said. I don't know if you want to come up to the microphone. I may have misheard you, and I want to make sure. I wrote down that you cited Cobb County Code Section 2-50. Did I hear you say Section 50? Yes. Because when I look at that, it's called incompatible employment. Is that what you meant to cite? And again, I may have misheard you, but I just wanted to make sure.
Well,
I
I'm gonna have to look at it.
It's in the written,
2-50 was no expenditure of county funds, et cetera.
Well, in my code, it's
That's what,
incompatible
that's what
employment.
he said. I don't know. I wrote down what he said for 2-50.
I just want to make sure I'm looking at the right code section.
he did cite 2-50 in his written documents.
In my excitement, I seem to have lost one of my pages, but here it is. 2-50, but that may not be the right one. I may have erred in that.
Mr.
See what,
Atkins,
2-50.
the 2-50 is not from the Code of Ethics. And Mr. Savage, I think what you were referencing was the 2-50
2-52, I'm sorry.
expenditures to be made in accordance with budget quarterly allotment system.
2-52 is improper use of office, harassment, improper influence.
Well,
The passage you cited is from 2-50, Article 2 of the Board of Commissioners, not of the Code of Ethics.
well, that's, I can apologize, and that's about all I can do at the moment, because I don't,
Well, there may be other questions. I don't want to
Yeah,
lay
let's
us.
give him an opportunity to find that.
Sure.
And are there other questions?
Yep.
Then we'll.
I'd ask Ms.
Mr.
Dance, please.
there you go. There is a code section, I have the number wrong.
If you don't mind, just see if you can find that and let us know. That would be helpful.
Mr. Jover, you have a question for Ms. Dance?
Ms. Dance, Mr. Savage talked about the 300 million cap, and then he talked about the expenditures of the 300, was it 68 million? And he kind of hinted that the board really didn't know what they were voting on, and it kind of snuck its way through. I sincerely doubt that because, if they're voting on it, I'm sure they knew what they were voting on. But how did that change, or how did 300 go to 368, just so for my own edification? Or why was it changed?
I'm not sure that it was changed. The documents that I review say that it was up to a certain maximum. So, there's a broad range in there. And so the documents that I reviewed and the documents that the board saw was it was authorized up to a maximum of $397 million.
Okay.
Mr. Chairman, if I could ask Ms. Dance a couple
Thank
questions.
you. Yes, Mr. Rodriguez.
The press release that Mr. Savage is referring to, is it the county's position that that press release doesn't come from the county and is not representative of the county commissioners?
Okay, as to the press release that he's referenced.
Right.
Those are his assertions. There is a page where he's shown a picture, and quite frankly, my position would be this, that this is untimely. If we were to get to the merits, we could certainly discuss that, but I'm not prepared to discuss that. But as to the point that the press release was prepared perhaps by a member of staff other than a member of the Board of Commissioners, which I can say is exactly true, then if there was a question, then it's a representation not by a person that he's brought the ethics complaint against, but by some other individual who perhaps has made a representation at a particular point in time. This whole deal evolved quickly, but it evolved over a very long period of time. So there are possibly and probably a number of occasions at which representations were made as to what the expectations were to be of the bonds that were to be let. And only until you come to that moment of consummation when all the documents are worked out, do you actually have the document that is put before the Board of Commissioners and upon which they vote and upon which their decision is made and which was executed certainly many years ago.
If I can ask you about the the deficiency as far as timing,
Excuse me?
sure, you mentioned that Mr. Savage's complaint is deficient because it's not timely.
Right.
I believe I heard you describe Mr. Savage as being extremely diligent in educating himself about these matters. You would agree that the ethics code doesn't require extreme diligence, but simply due diligence. Wouldn't it then seem that Mr. Savage has satisfied his obligations as far as the timeliness requirement and being extremely diligent?
I'm not sure how to answer you because I'm not sure the point that you're making.
Well,
The point I was making as to representing his diligence was only to recognize that this is an individual who was well-educated and to acknowledge the fact of what he did say himself. He was probably more educated than other members of the public. He also participated in litigation before the state of Georgia, and he knew that in 2015, matters were officially resolved by the state's highest court. So my point was intending to be that he was well aware and he was not surprised by something that he found recently, and therefore that I don't think that the standard of 6 months speaks to a question of due diligence at all.
well, I mean, you would agree that the Supreme Court's case and decision in 2015 wouldn't put him on notice of any vote that the commissioners made in 2017.
No, but 2017 is
Sure.
1 year prior to the filing of his complaint as well.
Right.
So that's outside of the period as well.
So, I mean, the board has obviously the option to find that the complaint is deficient. The board also has the ability to rule on the merits. If we were to rule on the merits, well, if we were to decide on whether this is a deficient complaint as far as the timing requirement goes, tell us what would have been due diligence over the past year. How would someone in Mr. Savage's position, someone in the public, what would due diligence look like in order to find out these documents that support Mr. Savage's complaint today?
In my affidavit attached to my response are copies of actions taken by the Board of Commissioners that are on the public record. They were voted on in public, and they exist on the public record. There are news reporters here who reported on these matters. All of these matters were well within the purview of the public, whether it was Mr. Savage or any one of you or anyone else in the county. So I don't think that anything other than the action of the Board of Commissioners on that date, that's sufficient to say that's the date on which the clock started to run. When the Board of Commissioners took action to approve 11.3 and people were aware, and if someone had a question of that was an ethics question, the burden was on them to bring it forward within 6 months of that time period.
Well, I mean, what if the board were to vote in June of 2017 to pay $11 million, okay, make an expenditure, and it turns out that after doing some digging, that the county had already made payments for the same thing before? I mean, how would someone know that that happened unless they looked into it?
Well, certainly the rules do provide that if there's an act of concealment, then there's a tolling of the six-month period. There's no act of concealment. There's no concealment that occurred. Everything was on the public record.
And that may be, but there's also non-disclosure, right?
No, I would disagree. When the board votes in public and makes it a matter of record what their actions are, That's the public record. It's before the public. It's the, if an action is taken in that manner, it's considered to be contractual, you know? And if I might address one other question you raised at the standard, you raised as to the standard, I don't believe that this board has the authority to consider the merits unless you have figured out whether or not the complaint is non-defective. Because if the question, as stated, is, whether there's any showing of a violation occurring within 6 months of the date of filing, which is another way of stating the standard, there is no evidence, he's presented no evidence that there was any violation of ethical standards that occurred within 6 months of the filing of his complaint. And that being true, this board does not have authority under its rules to consider his complaint.
Ms. Dance, I have a question. Actually, just clarification on information. And it's dealing with the reallocation of the 11 million from the water district. Was that on public record during a meeting that was discussed and approved?
Yes.
And where, okay.
Yes. So Mr. Savage actually attached it to his documents, but I believe I also went back and found the records. But it was a public meeting of the BOC. The actual document showing the payments, to whom they were made, the payments, the purpose, all those matters was presented at a public meeting. It was voted upon at a public meeting in June of 2017.
Thank you.
Well, I will ask one other question of you then, Ms. Vance. Mr. Savage raised the question of the gratuities clause. I was curious as to what your thoughts were on that, if you could address that.
The 2015 opinion of the Supreme Court addresses that and says that because the challenge in 2015 included a challenge to the gratuities clause, and they turned it down. They renounced his position, and they said that as a matter of law, there was no gratuity involved in the expenditure of the bonds.
Thank you. Are there other questions for Ms. Dance?
Mr. Chairman, could I ask some questions of Mr. Savage?
Certainly. Mr. Rodriguez.
Mr. Savage, why is the county bound to the press release on the $300 million cap, and how is that a violation of the Code of Ethics?
I cited the press release because it was the same day that the commissioners had voted on the guaranteed minimum price for construction, and it was very timely, and it was almost presented as a boast in there that the $300 million cap was still in effect. Whether the communications department acts on its own or at the direction of the chairman or the commissioners, I can't tell you in that particular situation. But it appeared to be a deliberate act on the part of the county to communicate with the public and assure them the $300 million cap was still in place. Now, there are I didn't read everything that I had. There are numerous examples in there, references to the $300 million cap and to the sanctity of the county's protected position and all that. And if you like, I'll get my notes out again and give you some more examples of that.
Well, can you answer the second part of my question, which is if the county is bound by this press release, the commissioners are bound by this press release of a $300 million cap, how is it a violation of the Code of Ethics to spend more than $300 million?
Well, as I said a little earlier, if you look at this as a contract issue, then I don't have a position because the words are in there. If you look deep enough, you'll find the $368 million as being an authorized expenditure. The ethical portion of it is the mismatch between the public message and the official message buried in the documents. That the message that went out to the public over and over again was that the county was fully protected, a $300 million cap, and that was repeated again and again, and everyone associated with it heard those messages, but only a very few people would ever see the 368 million that's buried in the various resolutions, and that's not prominently displayed. Interestingly, in all of the documents that existed over the stadium deal, and the bond validation package contained all of them, and it ran over 500 pages, there is no place where they give you a definitive summary of who's paying for what.
Well, I mean, in looking at this not as a contracts issue, but as a code of ethics issue, how is that a conflict of interest? How is that somehow evidence that one of the commissioners was receiving a personal benefit from spending more than the $300 million cap, assuming that the county was bound by this press release? I mean, what is the ethical violation?
Well, first of all, the press release is one of the later documents. It was not one of the original documents at all. And the original ones that I showed were the infographic, they called it, with the baseball image and all that. Those were the earliest ones, and that and the MOU had very specific language that said, here's what the county is going to be doing. This is what the county will be committing to. And the commissioners had this information, and they also had the other information. And the ethical lapse was when they when they actually not just allowed, but encouraged the public perception on one hand that was different from the reality.
Did any county commissioner personally benefit?
In monetary terms, I don't know that.
Okay.
If there are a lot of ways that one could interpret what a benefit is, but
Well, I'm talking about a benefit in the sense of an ethical violation.
well, I think dishonesty is an ethical violation.
The 11.3 million from the Water Authority. If I understand your allegation in the complaint, is that this impedes efficiency or impedes government. What evidence is there that the Water Authority is suffering, or somehow government efficiency is impeded by the county allocating those resources?
County allocated resources have been allocated by the Water Department for a different purpose, and the Water Department's purpose didn't go away. So they took the money away from its intended purpose for renewal and extension of the water system and used it for something totally unrelated. Now, there is, in the agenda item that the Board of Commissioners voted on, there is a discussion that asserts that some things called water vaults or stormwater vaults at the stadium site are being paid for with the $11.3 million. But the stormwater vaults on the stadium site were a part of the project. And if they were going to be paid for by anybody, well, should have been paid for with the stadium money. And why they would come back and want a separate payment for the stormwater vaults, which were a totally necessary part of the development. It is not an uncommon thing for a large development to have stormwater vaults, because if they cover so much ground with concrete that there's no place for the stormwater to go, they have to create, you see detention ponds around, where a subdivision will have a detention pond that holds stormwater runoff until it can gently flow away safely. These stormwater vaults are huge underwater detention ponds, if you will, concrete encased, and that's where the stormwater accumulates until it can drain off at a slower rate. That is a necessary part of the development, and was not something the county would be responsible for anywhere at any time. In fact, if I had accepted that as an argument, I would be complaining that that was a gratuity for the county to pay for the stormwater vaults.
Are you asking the Board of Ethics to find a violation of the gratuities clause of the Georgia Constitution, contrary to what the Georgia Supreme Court has now decided, has already decided?
The Georgia Supreme Court did not rule on that. The gratuity question was not in play in the bond validation. The only reason the gratuity question comes up today because the ethics code doesn't say anything about gratuities. The ethics code says that the commissioners are bound by the law that pertains to their work. And they all take an oath to support and defend the Constitution of the state of Georgia. And the state of Georgia is the premier or preeminent document over all the laws that apply in the state of Georgia. And if they don't comply with the Constitution, I don't know what's left.
Mr. Rodriguez.
Yeah, thank you.
Mr. Rodriguez has touched on my question. That's, in terms of the Cobb County Code of Ethics, Mr. Savage, do you contend that specific commissioners knew what they were doing was illegal or that they personally benefited from their actions?
I don't know that they benefited. I know that everything was done in a rush. There was a lot of, I really don't know, it was almost chaotic at the time. If you recall, we went from nothing to voting to go ahead on what at the time was described as $672 million project with about 10 days of discussion and not even much serious discussion. So to say that anybody even understood what they were doing, it was all by the seat of the pants at the time. Now, whether somebody got personal gratification from it, from being a player in a big event, I can't speak to that. But as I said before, I don't think the concept of somebody getting a reward out of their actions is necessarily limited to a financial reward. I don't know, and I would not assert, by the way, that anybody did anything that was criminally negligent or illegal. But I think people use bad judgment. And in the cases, particularly with $11.3 million and taking the money from the water department, I think they have behaved irresponsibly and have violated these code sections.
Thank you. Mr. Atkins, did you get an answer to your question?
Yeah, I was going to just make sure. Mr. Savage, did you get a chance to check that code section?
I was looking for it, and I finally got online to look at the clerk's code. And honest to goodness, it's in there. I just can't find the number right now.
Thank you. Again, if you should find it before we finish, I'd like to know.
Are there other questions for either party? Yes, sir.
A question from Ms. Dance. Ms. Dance, my question is, realizing that what we're here for tonight, we really have a narrow scope of what we're looking at. If you could help us understand, where does Savage versus the state of Georgia, the Supreme Court decision, where does it come into play for tonight's proceeding? I'm not talking about the merits of the case. I'm talking about the procedural and the preliminary look that we're doing tonight.
Right. When I was reading his complaint, I was unclear as to the ethical standard that he alleged was violated. However, he did allege in his first section that one of them was that there was a violation of law. With respect to that, this case speaks to the issue of gratuities, and contrary to, I will just read this portion, which I've attached to my affidavit, and this is in Savage versus State, a 2015 opinion. It says, the court finds, under the intergovernmental agreement, it is clear services to be provided constitute contractual consideration to the county, meaning that contrary to another claim by Savage and Hobgood, the IGA does not violate the Constitution's gratuities clause. So, I mean, that is specifically in there. So I do believe that gratuities were addressed. And all of these issues, specifically, Mr. Atkins, were raised at this point in history and decided at this point in history. So my only point from that case is, as to the statute of limitations, these matters were decided in 2015, and that means that as a matter of law, they're foreclosed, and they should not be a basis for claiming that there was a violation of law that was also therefore an ethical violation.
Pardon me, any other questions from the board for either party? Mr. Savage, would you like to be recognized? You're raising your hand for a purpose there?
Yes, I want to see if I can make a comment to clarify what about the gratuities matter.
You're welcome. You're welcome to do so. We'll give you 2 minutes.
There was a gratuities issue in the court case over the bond validation. It wasn't my position. It was somebody else had made the case on gratuities, and it was whether the county was providing an improper or illegal gratuity to the Braves by providing the stadium for them in a very beneficial relationship. That was part of the court case, but this is an entirely different type of gratuity from what we're talking about here. Here, we're talking about the gratuity of giving the money to the Braves in excess of what was a contractual obligation. So the gratuity in this case is the difference between 300 million and 368 million. And the gratuity in part two is the 11.3 million. That was money given to the Braves in excess of what the county's obligation was. So it's a gratuity in either case, but it's a different gratuity. And the ruling in the court case really has no bearing on the kind of gratuity we're talking about here, the nature of gratuity.
Mr. Ziober.
Yeah, I just don't understand. What you're talking about there is 2-3 years ago. And we had a lot of discussion about the 6-month thing in the last one. I don't even see where that has any that we should even be talking about that. I mean, we're not even looking at 6 months, we're looking 3 years. That was a long time ago, gone through the courts. It just seems like we're just going over something that we shouldn't even be discussing.
Well, that's the reason I want to make a clarification statement here, because the part of it that had to do with giving the Braves a stadium to play in at a very favorable terms, that is history. That was decided. What we're talking about now is giving them money beyond what the contractual obligation was, and that is timely because we didn't have the complete picture until this document was obtained here a couple of months ago. So there's a difference between the identification of the 11.3 million as a payment to the Braves and the 68 million as an excess payment to the Braves. Even though it took place a long time ago, we couldn't identify it until this last document surfaced recently.
Wasn't it public record at that time?
I'm sorry?
Wasn't those votes were public record at that time?
The votes don't tell us that. The votes.
They had to vote on the amount.
Well, that's what I said earlier, that we can compare. There are two different channels of information. One channel of information was destined to the public and was all about the $300 million cap. And the other channel of information was buried in the depths of the documents that most people would never see.
But the vote was public, it was on TV, it was a commissioners' meeting.
It's not in the vote, it's buried in the supporting documents.
But didn't they vote on 368 million?
Yes, they don't read those into the case, into the record.
Is that true?
It's in the public record if you are a determined hunter and wish to go and root for it, and you know it's there. If you don't know it's there, you probably wouldn't stay with it long enough to find it.
Mr. Atkins, we'll come to you. Mr. Gibson.
Mr. Savage, is it your position that things that happen in this room with the Board of Commissioners, if there's not a verbalization of what they do, in other words, if they vote on something that's in an agenda item that they don't literally read out, is it your position that the public is not on notice of that?
That would be true. Yeah, the information is public to the extent that it is published in some form somewhere. Most of these meeting agendas are not published in the newspaper. They're not published any place beyond the county's website. Now, if you come to the meeting in person, you may see a paper version of an agenda summary. An agenda summary is typically 10 or 12 pages, where the entire agenda with all the documentation and attachments may be 400 or 500 pages. So yes, it's there. If you're a really diligent researcher, you can go and find those things. And that's the reason I try to make the distinction between the very public promotion of the $300 million cap versus the reality of the $368 million. I mean, I was in this for I had my head into this almost embarrassingly. And it still shocked me when I saw the document that said, yes, we put $368 million into the construction fund. And the shock was amplified when I saw that the promise of how much the Braves are going to put in was about half of what it was said to be. And the stadium itself was $100 million under what the forecast was going to be. I don't think any of that's coincidence, but that's not the point. The point is, did they violate the code section? And I think they did, yes.
Just one follow-up.
Please, yes.
Sorry. So it would also be your position that things that are published in the minutes of the Board of Commissioners, if they're not literally read out loud in this room during their meeting, that the public is not on notice of those either?
I'll give you an example that's very much on point. When the vote was taken on the $11.3 million, I don't have the documentation with me, but I looked up the agenda item, and it was so plain vanilla that it said that we're going to vote on an open issue with someone. It didn't even name the Braves. That was on the short agenda. The longer agenda had a transmittal letter, and it had very little more in it. And I read everything available. I went back later and read the minutes to see if anything new showed up in the minutes. And I couldn't find out why they were giving that money to the Braves. I did find, that is the letter is where the mention came of the stormwater vaults. But that was a non-starter as far as logic is concerned, why they would be paying for the stormwater vaults. And there's nothing else you can do. You can ask until you're blue in the face, but there's no information to be had.
Mr. Gibson.
Mr. Savage, this document that you're mentioning, this subsequent, I just want to clarify, you're talking about this press release? Okay.
Well, I'm sorry, state your question again, because I don't want to overemphasize this press release.
Yeah, you referenced a subsequent document until this document came out. Are you referring to the?
No, I'm referring to the financial summary that I obtained through the open records request.
Okay.
Until I had that financial summary, I couldn't really bring a case to this board. I didn't have enough to close the loop and say, yes, I can tell you that I believe there's we wouldn't be having any of this discussion if I had come in without those numbers, because I couldn't really make the case.
Other questions? Thank you, Mr. Savage. Mrs. Dance, do you have another point? Please.
Just to the point of the Supreme Court decision, the Supreme Court decision is actually a validation of the bonds that were issued. So not only did the action occur in this room, the Supreme Court heard all these matters and validated the bonds. He wants to talk about the contribution in the middle of this case in which he stood before the Supreme Court. It says the total cost of the project is anticipated to be $622 million, et cetera, with the bonds issued by the authority that will pay for $368 million of the project. It's clear that the public was on notice, that Mr. Savage was on notice, particularly he stood in the room when the court considered this. I'm sure he got a copy of this opinion. It's been established for several years.
Thank you very much. Well, it's now our responsibility as a board to deliberate publicly and have a discussion. I want to reiterate what Mr. Rainey told us at the outset, that we had access to the complaint and to the information presented. Now, we've had an opportunity tonight to listen to specifics regarding that, but we've had no discussions publicly, privately, or among any one of ourselves. I would like to ask Mr. Rainey briefly if you have any further thoughts regarding gratuities clause or anything else that you'd like to elucidate us as to, or if you have any further thoughts as to the Cobb County Code of Ethics as it relates to tonight's proceedings.
No, not without appearing to be partisan in one way or the other, because I am in a neutral position to advise the board regarding the discussion about the gratuities clause and the decision from the Supreme Court. The board has had a copy of it because it was attached to the county's response, and so the board has had the opportunity to review it and read it and make its own determination as to what it says and what it doesn't say.
Thank you, sir. I'm grateful. Discussion?
Yeah, I'd like
these separate counts?
I'd like to say in the information that we received, it was pointed out as to what our responsibilities are. And it says the Board of Ethics is not a forum for disagreements over politics, policy, and independent judgment. And I think a lot of the things that we're talking about as far as the voting of the commissioners is their independent judgment. I mean, that they're voting, whether you disagree with it or not, they're voting the way they want to vote. And the ethics board has to just look at allegations if there was a conflict of interest or there was a financial interest. And I really have not heard anything pointed out that anyone gained financially or that there was a conflict of interest. Everything we've heard so far is just, I think Mr. Savage and the other folks are in disagreement the way the thing was handled, which is a policy and that, but I don't see it being an ethics violation.
I agree with that. And I guess the best way to put it, and we're not bound by this language, but in the Supreme Court case, Justice Namias wrote toward the end of the opinion, he said, while aspects of the deal structure at issue may push the law about as far as it can go, it does not cross the line into illegality. And I think exactly what you said, you know, the question is not whether we agree with how this was handled. The question is not whether we agree that it was a good deal. We have a very narrow role here, and that's to determine tonight whether this needs to move forward under the procedures and the ethics code. So while it may be interesting as to whether or not the Supreme Court dealt with the gratuities issue, that's really not relevant to what we're doing tonight. I'm having a very hard time getting past the time frame. In my view, everything that has been argued tonight is available. It's out there. I view the Supreme Court's decision, and I remember I practice local government law, so I keep up with these things, but even if you don't, and I know most people don't, this was in the news. Mr. Savage, with all due respect, Mr. Savage was a party to this case. The court mails out decisions to people. In this decision, the court mentioned the $368 million. It is a long decision, I agree. But Mr. Savage is very sophisticated. I can't say the word. He's very bright. He spent a lot of time viewing what the Board of Commissioners do, and I think he's to be commended for that. I think it's important for citizens to keep an eye on what goes on here, and I commend you for that, sir. But I have a real hard time getting past the fact that these numbers were out there in 2015, and here we are now. Now, that's the $300 million issue. Then when we get to the issue of the 11 and something million dollars, there again, that was well reported. It was voted on in this room. It's in the minutes. It was on TV 23. I just don't think it was hidden in any way. And the transfer, the water system transfer issue is the same way. You know, there are a lot of people that don't like these water system transfers, and who am I to say whether they're good or bad? That's really not my decision to make. But the fact of the matter is that was out there. It was out there in the press. It was made public, and we are bound by our code, which requires us to follow the code, and you have 6 months to bring these complaints. And unfortunately, that just didn't happen here. I have a hard time getting past that.
Mr. Atkins, if I can suggest, in responding to that to this board, 2-78, paragraph 3, that sets out kind of the procedure for resolving these complaints, having this investigatory review. My reading is that this board can dismiss the complaint on the basis of a technical deficiency rather than upon the merits of the complaint. Mr. Savage was informed of technical deficiencies, 4 of them. He was permitted to amend his complaint. Okay? Maybe there is still a deficiency as far as the 6-month time frame. But I don't believe that this board has to dismiss it on that ground. If we were to dismiss it on a technical deficiency, Mr. Savage would then be permitted to refile again in an attempt to cure the deficiency, and then we're back sitting in this room doing what we're doing already. I would suggest that we go ahead and rule on the merits because we can. We don't have to dismiss it on a technical deficiency. And having heard everything from Mr. Savage, he hasn't alleged a violation of the Code of Ethics. We can decide this complaint, rule on this complaint on the merits. I asked him point blank if anyone on the county commissioners personally benefited from any of their decisions, and there's no evidence of personal benefit. You know, the Code of Ethics in this board requires the impartiality and the independent judgment of public officials, and it's the independence of judgment that shields from improper influence or personal benefit, and that's what the Code of Ethics is all about. And I haven't heard any evidence from any credible sources, and I'm not saying, Mr. Savage, that you're not a credible source. I think Ms. Dance acknowledges that you are extremely diligent, and I agree with Mr. Atkins. I commend you for being so vigilant on the actions of our government. But it's telling to me that notwithstanding your vigilance, there's not any evidence that one of the commissioners improperly benefited personally, professionally, from any of the decisions. And I don't think that we have to hunt for ethical violations. We rely on the complainant to present this board with evidence that you believe amounts to an ethical violation. You know, Mr. Savage disagrees with the decisions of the county's Board of Commissioners, a position to which he's entitled, a very respectable position to take. But nothing in the complaint even comes close to suggesting that a single commissioner's personal, business, or professional activity conflicted with their responsibilities as a public officer. And beyond the conclusory assertion that the commissioners gave preferential treatment, you haven't identified a single person that received preferential treatment. And that's what amounts to an ethical code violation. Nothing in the complaint, the supporting affidavit, or any of the documents identify a person that received any sort of improper preferential treatment. I don't read the code's prohibition in a vacuum, that no officer shall impede government efficiency and economy. The fact that funds were allocated for one purpose over another, there's no evidence of government being impeded, any sort of inefficiency. I think quite the contrary. You know, storm drains, I mean, those are necessary. I don't know how paying for storm drains makes our government any less efficient. But what the code is talking about is prohibiting public officers from placing their private interests in conflict with their responsibilities and duties of public officers. Again, I think that we should go ahead and rule on the merits. It's my recommendation that is to count one. The Georgia Supreme Court, they've already decided it, and we should follow the Supreme Court's guidance. I can't find any credible evidence of an ethics violation based on conduct that our Supreme Court has said is not unlawful or unconstitutional. And then as to counts 2 and 3, I would recommend that we dismiss on the merits, having not heard even the suggestion of a conflict of interest or impartiality or any other conduct prohibited by the Code of Ethics.
Thank you, Mr. Rodriguez. I appreciate your thoughtful consideration. Others?
I'm in agreement with Mr. Rodriguez. I think we should dismiss on merit. I think reasonable people can agree or disagree how you conduct government, how you govern, what votes you take. But I have not seen evidence of preferential treatment, conflict of interest, any one individual benefiting from um, from this situation. So I'm in agreement with Mr. Rodriguez.
What about it? Justin, I'll put it. Mr. Gibbs, would you like to add?
I'm in agreement with Mr. Rodriguez. I don't think that there's been evidence of any conflict of interest presented.
This is Dr. King.
I too agree with Attorney Rodriguez regarding dismissal of this process.
I too asked a specific question regarding whether anyone had specific allegations as to whether the commissioners knew what they were doing was illegal or in any way benefited, and I see no evidence of that either. Any further discussion before we entertain a motion? Is there a motion?
I'll make the motion that we find no specific substantial evidence from credible sources exists to support a reasonable belief that the commissioners had violated Cobb County Board of Ethics, and accordingly, Mr. Savage's complaint is dismissed.
Is there a second?
A second.
Second.
I'm sorry, who's a second?
Dr. King?
I second.
Got it, thank you.
Dr. King, second. All in favor of the motion, say aye.
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 Unanimous. We want to thank the parties for their effort. Mr. Savage, I would like to particularly commend you on your efforts and your time that you put into this. I must say, however, that there are issues here. Every one of us up here may agree with everything you say, but unless there's specific allegation that the commissioners benefited personally, knew what they were doing was illegal, our mandate is very limited, and there are other forums in that for which you might address that. That would be the Superior Court of Cobb County, but this body doesn't have the authority to engage, to make decisions on some of the areas that you've alleged within outside of the narrow confines that the Cobb County Code of Ethics imposes upon us. The next regular meeting of the Cobb County Board of Ethics will be on October 2nd, 2018 at 6 p.m. in this room, unless we're notified otherwise. Is there a motion to adjourn?
Second.
All in favor?
Aye.
Thank you for your attendance.